Judge Majiedt,
Good afternoon, CJ.
are you well?
Very good, sir.
I'm fine. I will assume that you're not yet settled, like those who came before you. I'll try to make you comfortable
Yes,
first.
thank you, CJ.
For how many years did you practice as an advocate before you went to the Premier's office?
I think it was about 14 or 15 years in Cape Town.
In Cape Town?
Yes.
And
In fact, it was 13 years, sorry. 13.
1-3.
Yes.
And for how many years were you with Premier Majiedt?
3 years.
3 years.
Yes. What had happened was, you would have seen from my CV in '94, I was asked to go and assist in running the elections. So 3 of us ran the elections in the Northern Cape. You know, I come from there.
If you could bring the mic closer, you are a bit soft.
Yeah, I'm saying in '94, I was asked to come help run the elections in the Northern Cape because I come from there. And so I went there, and then I was asked by some people in the ANC to come and work there just to get the province started, because my father was involved in the structures, and so they knew me. And so I decided to come, but for a limited period, because my first love was the practice of law, not a bureaucrat. And so that's how I ended up in the Northern Cape.
And for how many years were you then at the bar after leaving the office of the Premier before you were appointed to the bench?
Oh, it was just a few months, and I started acting in March 2000, and at the High Court, and then May 2000, I was appointed as a permanent judge. So I've been a judge for 19 years.
Yes.
This is my 19th year.
Was there no insistence on the cooling off period?
There was, and I thought the cooling off period wasn't long enough, but I was pushed by some people to make myself available.
And you allowed yourself to be pushed?
Yeah, reluctantly so, because I was making good money in practice those 3 months.
Yes.
Very good money.
So for how many years were you a High Court judge before you went to the Supreme Court of Appeal?
Exactly 10 years, and then I went to the SCA permanently the 1st of December 2010.
Yes.
I must say, before then, Chief Justice, I had been asked by former President Mpati to come some 3-4 years earlier, and I said to him, I'm not ready, because I realized that I was in a small division and that I needed as much experience as I could get. But eventually, 2010, I felt I was ready, and I went.
And are you one of the presiding judges, at the senior judges at the Supreme Court of Appeal?
Yes, I am Chief Justice, but I'm not one of the top 6.
Then you can go.
On a lighter note, since it is not a statutory structure, how do you qualify? Just on a lighter note, are you elected or what? How do you get to the top 6?
No, it's just a matter of natural progression.
So
I'm not there yet.
So if you're not appointed to the Constitutional Court, you're likely to end up there?
Yes, it would, I think.
Okay.
I think I'm number 7 or 8 now, so I'm just outside the top 6.
You're very close.
I'm still in a fairly safe zone for now.
And well, while we are there, what challenges are there at the Supreme Court of Appeal?
Chief Justice, you know,
in fact, yes. What challenges are there, if any?
Well, you're talking about interpersonal relationships, I take it. I was here 2017, as you know, unsuccessfully for this post or for the other previous post. And I did disclose that there were problems. The problems are still there, but I must say it has improved a lot. And that, again, as I said in my interview in 2017, I ascribe to leadership, strong leadership from President Maya. We had that diversity seminar. In the last interview, I alluded to the fact that it was like preaching to the converted in church. Those who were there were not really the problem, by and large. And I'm not saying all of those who weren't there are the problem. But it is a first step in a long journey. I also said in 2017 in the interview that it's not an event, it's a process. And I think the process is on track. There's a lot more collegiality. But we've got a long way to go. We still got a long way to go, and there are still recurring unpleasantness and unpleasant events which we can't shy away from. But I think all of us are working on the issues.
If you're comfortable to be a bit specific, how do these problems manifest themselves?
Well, quite frankly, it's not exclusively, but virtually always when it comes to judgment writing time. Now, people are allocated judgments to write. You write, and then colleagues, senior colleagues find fault with it, mostly justifiably so. Because experience is not something that you can get overnight. And so it's a learning process, and some of the juniors and the AJAs struggle with writing judgments. I also struggled when I got there. It's a learning experience. And the problem is how it is being handled. Some of our colleagues handle it very constructively. Others, regrettably, not. I have been fortunate that I have not really been on the receiving end. Except for one occasion when a colleague, many years ago, 2011 or 12, spoke about me, about a judgment behind my back in the presence of two colleagues, and the two colleagues promptly told me what he said. And after the conference, I said to him, I want to see you alone, and I said to him, you must never ever do that again. You speak to me about my judgment, to me, not about me. And I think the colleague saw the light. And so things were never really the same again between us, but there is, I think, a healthy respect with that particular colleague and myself between us. And he knows where I've drawn the line, and that's it. I must say, Chief Justice, unfortunately, and that is the reality, sir, it's not that always that easy for women colleagues. And there is a strong perception, I think justifiably so, that women, junior judges and acting judges suffer the most. And in the last term, there's been another incident where a woman judge was at the receiving end of a very unpleasant episode. And so, I've been fortunate. I must also add, Chief Justice, excuse the long-winded answer, but this is an important aspect for our court. The other side of the coin is that we, all of us, including junior judges and acting judges, must pull our weight. We must do our work. And I said in the diversity seminar, colleagues, each one of us need to look in the mirror and say, have I done my best possible in this judgment? And if there are shortcomings, we must accept it like a man or a woman and say, this wasn't good enough, this is constructive criticism, and I will take it to heart, and I will learn from this experience. As long as the criticism is constructive, it builds you up, not breaks you down, then all good and well, and then we all learn and we grow. But we must look in the mirror and ask, is this really good enough? Because we try to maintain a certain standard in that court.
Is there a system in place, or would you suggest that a system be put in place that is designed to help newly appointed judges, acting judges, understanding some of the challenges that they go through? Yeah. A structure, for instance, that could be meant to ensure that when they write judgments and they are not yet, they have not yet developed their judgment writing skill for that level well, there are colleagues around to mentor them, to assist them, and it's not just a question of the usual expression, my door is open, it's always open. You know, people, I don't know what it is, my door is always open. A very deliberate plan to assist. You know that there is Judge so-and-so, I can go to them. And two, a deliberate plan to tackle head-on those who behave as if you are there at their mercy. To have a meeting and not to be timid. I never understood why a judge should be timid. I never understood. To say, colleagues, let's have a meeting. Raise your issue, raise your issue. Why are you doing this to colleagues? And confront those who, over the years, have reportedly been making life difficult for other colleagues. Is there a system in place to do that, or do we die in silence and in our corners?
As Chief Justice, there is a committee which basically orientates acting judges when they come to the court for the first time, and I serve on that committee. And the late Bosielo J.A. chaired that committee, and for a short while I was acting chair. So what we do is, when acting judges come for the first time, we take them through practical things like how the court works, how conferences work, and so on. But there is not really a system in place where people can get mentored, and I'm a strong proponent for a mentoring system. I heard from some colleagues that they have a strong mentoring system in some divisions, for example, I think Gauteng. And that is something that appeals to me in the sense that if I get allocated, for example, 2 acting judges, I don't think I'm senior enough, but let's use me as an example. Or Judge Kachalia over there, he's got plenty of seniority. And those 2 are my responsibility for, let's say, the first term, or even for the first 2 terms, or for the entire year. And I look after them in the sense that I'm not going to patronize them, but when they need help, they know where to go. And it's a system that commends itself to me, and I think we really need that. As for the second part, the question of the seniors misbehaving, or some people misbehaving, and unfortunately one generalizes, but it's not all the seniors. But I think there the head of court must play a firm role. And I really think this thing should be confronted head on, bluntly now, because we've come a long way. We can't still have this.
It's been going on for too long.
Correct.
And not all judges are as bold as you are. Speaking for myself, I've been in difficult circumstances, but nobody ever had the capacity to intimidate me. It never mattered how many they were. They knew they would get it properly. But how then do those who have what it takes to confront those who make life difficult for others help those who get victimized in the process? What is it that they can do? Can't they talk this over and say, you know, here is a program of action or plan of action. This is how we must deal with this thing, in the spirit of collegiality, of course.
Yeah. Chief Justice, the particular female judge who was acting came to me and to others, and she explained to me fully her problem, and I was actually aghast at what was said. Of course, it's only, A, it's hearsay, and secondly, it's the only one part of the story. I haven't heard the other side. But I was really concerned about it, and I thought that what should happen is that when the president returns from leave in the next term, she should be alerted to it, because that acting judge is now gone. She should
now?
She's left the SCA. She's gone back to her division. The president should deal with this situation head on with a colleague concerned. And if that doesn't have the necessary results, we must discuss it in a general meeting. And if that doesn't have the necessary results, then perhaps it must be escalated to the Chief Justice's office before we get to the point where complaints are laid and it goes to the Judicial Conduct Committee, etc., etc. But the point is this: I think we've let this thing linger for too long. The boil is festering and it's festering, and when it bursts, it's going to be ugly.
Well, and it's already embarrassing that it gets discussed on a public platform like this.
Yes.
Yes.
And Chief Justice, sorry to interrupt you, but I just want to say this. I know when I go back there in the new term that people are going to be unhappy about what I said, because there was unhappiness in 2017 when we went back there, and some of our white colleagues said, but you know, our children are asking us, are you the racist referred to there by Majiedt et al. At the interviews? And unfortunately, this is the things that in South Africa today we must meet head on and deal with. And it is perhaps in some instances not so much racism as a question of egos and and an intellectual superiority aura around certain people.
And it doesn't only come from white colleagues.
No, exactly.
Yes.
And the victims are not all black. So it's much more complex than just black and white. And so
Judge Rogers, was it Judge Rogers? Yes, during his interview indicated that he was subjected by one colleague to treatment that is less than acceptable.
well, I was in that panel and I was really, let me say this, something happened in open court and I was ashamed to be on that bench.
Yes. To a colleague.
Yes.
Yes. Now, you are involved in many things.
My wife said too many, Chief Justice.
Yes, you are the Chancellor of the Salt Lake University. I heard you when I went to deliver the lecture there, that you raise funds. You are involved in the training programs of the South African Judicial Education Institute. You are involved in the Judicial Case Management Committee. How do you manage to juggle all these and your involvement in golf clubs with your judicial responsibilities?
Yeah, Chief Justice, I've relinquished most of those. My term at the Rules Board as chairperson has come to an end. My term at Sajay has come to an end. And so now I'm involved
Sajay?
In Sajay, yes.
You are not permitted.
Sorry?
You are not permitted to live there, but we'll talk about it.
And the golf club, I was chairperson for a while, some time back. And so I've scaled down a lot. Chief Justice, I try to help where I can. You know, as I said in the last interview in 2011, you asked my now retired colleague Brandt, JA, to help with training. He then wrote me in. And so I've been doing that since 2011. And I'm one of those persons who believe in a succession plan, that you start grooming other people to take over from you, because I don't think you should cling to a position or cling to something. And so my colleague Matopo J.A., who's been with us in the program for many years, has graciously accepted my request to take over the training of aspirant judges. It's been a very rewarding experience. But I still avail myself. At the end of this month, Chief Justice, I will be joining some senior colleagues who will be going to Gaborone in Botswana at their request to go and train some of the newly appointed judges. So I'll be part of that too.
Yes, I remember last year, July, when, was it August? No, August, when I was there, the Chief Justice of Botswana asked me if I could facilitate training for about 8 of their judges, and we have agreed.
Yes.
So you are in that team?
I'm in that group, yes.
Yes. Now, why do you want to leave the SCA instead of helping to confront the challenges there? Why do you want to come to the Constitutional Court?
If I may be permitted to be facetious for a moment, after what all you've heard over the last 2 days, can you blame me? Chief Justice, on a serious note, as I've said, I wait when the time is right. I believe I can contribute to that court. I've waited for 9 years. And I had a lovely stint in 2014. Thank you for the invitation. I wrote some judgments which people can ascertain for themselves whether it was useful in the jurisprudence or not. And I found it it's a different way of working in the SCA, but I found the collegiality there very, very good. It's a very, very welcoming place. And of course, now it's the apex court. And I think this is a very important round of appointments for the JSC and for the President in particular, with great respect. Because after August 2013, after the 17th Amendment, Constitution Amendment Act, when the jurisdiction of that court was expanded, it now becomes much more important that you have generalists and in particular judges who have knowledge in fields other than constitutional law. I'd be the first to admit to you that constitutional law, and quite frankly, has not always been my first love. It's something that as a common law lawyer, one needs to get used to and adjust, and I say it with quite frankness and boldly. But now the whole scenario has changed. I want to venture to suggest, I've got no evidence, but I want to suggest that you will find that the cases that come to you, those few and far between, there will be more cases that would normally not have come to you, would have ended at the SAA, than constitutional cases, purely constitutional. Of course, the Constitution permeates all law, but when I say that 2013 has changed the ball game, and I think you need at that court, and I said the last time in the interview, it's difficult for me to blow my own horn, but I just read in Proverbs this morning in Faith for Daily Living that a passage from Proverbs that said, you must never allow yourself to think that you are more knowledgeable than you really are. And that's my difficulty, but I want to suggest that I can make a contribution. I've written judgments on customs and excise and tax and dealings and contract, and my record is there. The judgments speak for themselves. So,
Minister?
Yes, I just wanted to follow up on the question by the Chief Justice about your exodus, post-exodus from the SCA to the Concord, given the circumstances that you'd be leaving behind. And I'm just asking myself, obviously, whether it's career upward mobility or horizontal, I don't know, but I would want to put it to you that this country would best served if you stayed a little longer. You see, I see an apple tart in you, the soft part and the firm part. The soft part more exposed to those that are more vulnerable and who readily find you, you know, the shoulder that they need to give support when they need it. But the firm part as being this person who's not arrogant but prepared to stand his ground in order to correct some of the problems that have been alluded to. And I feel that that task has not yet been completed, and that you could make a very, very important contribution in normalizing relations and correcting some of the difficulties that that court is going through, rather than walk away so soon. I fully appreciate your readiness to go to the other court. I wouldn't begin to qualm you on that, but I'm just asking you, if you had to assess between the two options, don't you think staying on a little longer is likely to help the situation at a time when that is most necessary?
Yes, Minister, thank you for the kind words, but I would respectfully beg to differ. Sir, I've waited long. It's my 9th year in that court. I've waited long enough, I think. I've considered this very carefully. I am satisfied that that court is in good hands with the new president and the newly recommended Deputy President Petse and other senior colleagues. I think I have a role to play now in the Constitutional Court. I think my career must move on. I've always said to myself, if I could spend 10 years in the High Court and 10 years in the SCA, I would have done well before I get to the Apex Court. And my 10 years are almost up in that SCA, and I really think that I'm ready to move, Minister. I've made my contribution. I want to now, all really I want to be now is to be a good judge, to give the taxpayers value for their money. And I can do so in the Apex Court, I believe, with the utmost of respect and humility.
Thank you, Chief Justice. It was not meant to serve as any obstruction in your career mobility. Thank you.
Thank you, Minister. But just to say, purely if you were to boast a bit, based on your contribution to the development of our jurisprudence, especially while you were acting at the Constitutional Court as well, How would you say your contribution compares to the other 5 colleagues, to that of the other 5 colleagues?
Chief Justice, I'm very hesitant to
It's not time to be humble.
No, but I don't want to knock other colleagues. I think you've got 6 excellent candidates. And again, I don't like blowing my own horn. I'd like my record to speak for itself, but I can say this. When you read my judgments, you will see that I've grappled with very difficult issues. One of the cases that I didn't cite in my Annexure A to my questionnaire, I remember that afterwards, was a case in 2011 or 2012, which was the Commissioner of SARS versus MultiChoice. It was a customs and excise case. Remember then I was only barely 2 years at the SCA. It was a customs and excise case, a very difficult case, because it concerned the correct tariff classification of what we call MNET's 720i decoder. Now there's a lot of technical evidence, but also very difficult to exactly classify in the correct place, because that would determine the ad valorem duties that MultiChoice had to pay on those decoders. And after I'd written, I said to the senior who gave me, Tom Kluter, who's now retired, I said to him, Tom, you know, you're throwing me at the deep end. He says, well, what are you doing here? You got to start doing these cases. And after I'd written that case, colleagues came to, not reported, colleagues came to me and said, well, that is an excellent judgment. I'm very proud of that judgment. Coming to the, and that was a while back, that was 8 years ago. Coming to the Constitutional Court, I think the case that stands out for me, obviously, is the torture case. And I made the almost fatal mistake last time of saying that Moseneke DCJ allocated it to me. I'm sorry, you did. And I'm very grateful for that opportunity. And I said in my interview the last time, and I want to repeat it. In the SCA, it works differently. In the SCA, the top 5 or 6 judges will start allocating from the top, and they will give the nicest cases, the best cases, the cases that involves law, that involves precedent, that involves being reportable to themselves and to others. And by the time it gets to you, you must be satisfied with the breadcrumbs that fell from the table. Not so in the Constitutional Court. I remember speaking to Moseneke DCJ afterwards, informally and socially, when him and I and 2 others had a game, a round of golf at Houghton Golf Club. I said to him, but man, you know, again, yeah, I'm going to sink rather than swim. He says, but this is the case where you can make your mark. And I understood that there's a completely different mindset in the Constitutional Court. You get work, really, that you would have thought the CJ or the DCJ or one of the other top senior judges would get.
Top 6.
It sounds like a political organization, but really, I think that case, I've made my mark with that case. I put a lot of work into that case. I've learned so much about international law, about torture as a crime against humanity, and its enforceability across boundaries. That is really the case where I've made my mark. And again, I'm very proud of that case.
Just by the way, and because you touched on it last year, the last time you were here, although it was in a slightly different, from a slightly different angle, I've been forced to reflect quite a bit on the concerns raised by the First Nation people, of which you are one, about not being given the recognition and treated with the dignity that they deserve in a number of areas, including their language, or languages rather.
Yes.
Now, shouldn't we take it into account that there is a need to have the First Nation people represented at a highest level?
Chief Justice,
over and above the other qualifications?
Yes, of course, the constitutional imperatives, of course. Chief Justice, yes. You know, it's a strange sort of situation. In 2012, in December, I was asked to speak at the University of Stellenbosch about the question of coloredness, in inverted commas, in South Africa. Now, I said in my last interview, I hate the appellation colored. God made me a human being, and the National Party, through the Population Registration Act, made me a colored. So why should I cling to that appellation? But the overwhelming majority, maybe I shouldn't say that, I'll get into trouble when it's in the newspapers tomorrow. Many so-called colored people see them as colored. But what many of us have forgotten in this country, that we are indeed the first nation in this country. And I want to, just for a little bit, if you will allow me, tell you a little bit about my history. People always ask me, why do you have a Muslim-sounding surname, but you're obviously not Muslim, you're a practicing Christian? And one of my colleagues, one of my cousins was very interested in history. I'm not really, and I regret that many days, but he traced our history back to the 1800s, and he found out that there were 3 slaves called Majiedt who came from the island Java, which is now part of Indonesia. They came to the Cape as slaves, and they worked at the Cape as slaves. 2 of the brothers stayed behind, and so you find many Majieds in the Cape Peninsula and surrounding areas, but they spell their surname completely different, and they are still Muslim. But the 3rd brother moved inland. He converted to Christianity, and he married a Khoisan woman, and that's where we come from. Majieds in the Northern Cape and Namibia mostly. We are descendants from that Khoisan woman and this Muslim slave. And so, yes, I think it's terribly neglected. When you look at the people, the language is almost gone, but I have some good news, Chief Justice, is that outside Kimberley, there is a nation that has been resettled, the Ku and the Kwe. And it's a wonderful story. They go to school, they get tuition in their own language. They have their own radio station. They have produced printed material for the children in their own language. And so there is light at the end of the tunnel, but we've got a long way to go. I'm giving a long-winded answer because at the University of Stellenbosch lecture, I said, when I was asked about what is the position in the judiciary, I said, I don't want to be appointed, and by then I was already in the SCA, I don't want to be appointed to the Constitutional Court simply because I'm a colored, in inverted commas. That would denigrate me. Because if you have to classify me, I'm black. If you have to. I'm a human being, but I'm black. And I know I'm going to be asked about the skirmish with my former JP. I hope not, but it's in the press again. I say again, I will not in this country allow anybody to trample on my rights because I'm not black enough. Because under apartheid, I wasn't white enough. And so I will stand up for that kind of thing. I will definitely do it differently. But do not recommend me because I'm colored. Please. If you recommend me, you do because I've got merit and I'm black. Yes. That may count against me, but I'm saying to you now, I'm very proud about that, and I'm very firm about that. I will not be reminded about the National Party making me a colored just so that I can get a job in the Constitutional Court. I don't need it.
Well, you know, a man by the name of Dr. Rubens Richards actually says there are coloreds and there are First Nation people. Yeah. And he has written a book of about 800 pages. I read that book.
I know that book, yes.
You know that book.
I haven't read it, but I know it.
Yes. So he makes a distinction, but we don't have to go there.
Yes.
He says, for instance, if an African person and a white person give birth to a child, then that one falls properly under the classification of coloreds, and others are actually proud to be referred to as coloreds. Yeah. But then there's a category of First Nation people.
Absolutely. And Chief Justice, you're absolutely right. And one would probably call that biracial people or something along those lines. But when I talk about First Nation, I'm talking about people like myself.
No, that I understand.
Who come from the Khoisan.
I understand that. I understand that there is that distinction. Yes. So as I understand you, it should not be a factor.
No, and just on a lighter note, I always say to people when they have an African father, for example, and a white mother, or the other way around, they always say, you know, my mother's white. They'll never say, but you know, my father is African. I don't understand that kind of sort of mental slavery where you quick to acknowledge that.
Yes.
Look, or my great-grandfather, you know, my great-grandfather's white.
Yes.
As if that makes you better than other people. But you wouldn't acknowledge that your great-grandmother is black. She must be, because otherwise you wouldn't look like it.
And for what it is worth, just to give some perspective to where I was coming from, I was wondering what Section 174.3 means. And two, I've had a number of engagements with the First Nation people. And one of their problems is we are not represented anywhere in a structure that matters. Your argument, as I understand it, is no. Just look at competence, that representativity, just deal with me as one of the black people. Don't try to isolate me as either a person of Indian descent or a First Nation person.
Yeah. No, I agree. Chief Justice, I think it's intellectual dishonesty. If you never propagate First Nation status, which I've never done, all I'm saying is we must recognize our forebears, but I'm not going to use it to my advantage. Suddenly now,
as a ticket now.
Exactly. Suddenly now it suits me now. Hey, I'm First Nation, bear that in mind. No, I think Section 174.3 is clear.
Yes.
It talks about demographics, it talks about black people, and you will know from the Correctional Services case, which you've decided in the Constitutional Court, what you've said about what does demographics mean per province, etc., and what does it mean nationally.
Commissioner Nogesi?
Thank you, Chief Justice. Good afternoon, Justice Majiedt.
Good afternoon, Mr. JSC, and congratulations again on the LSSA appointment.
Thank you. Justice Majiedt, perhaps everybody knows, it has always been my concern that in the Concord you have that limitation of people to serve 12 years. And that is the position now, which we are still grappling with. But what is important in your application, I see that we are still below. In fact, let me say you were born in 1960, so you will serve that court enough.
Well, I'm 58. If I have to serve 12 years, I can do it until 70.
Yes.
And I became a judge at a very young age, at 39. So
Yeah.
19 years is a long time, but I'm only 58 still. Yeah.
Thank you. The second question is, you joined NADEL way back in 1986. That is at the early stages, or at the
Well,
formation
I think I was a founder member.
Yes. And one of the reasons for formation of NADEL was firstly to dismantle apartheid with its structures and institutions, to build a South Africa founded on the Constitution and the rule of law. How that process has helped you to grapple with the directions that this country must take and the transformative mind that is needed for a constitutional court judge.
Yes. Yes, I was very young again when I went to the bar. I was 23 when I became an advocate and started practicing. I was very fortunate to be on the same floor in chambers as an advocate, as luminaries, and I'm going to say it straight, frankly, struggle stalwarts like Dalla Umar was on my floor, and Siraj Desai and others. In fact, they used to call us the ANC floor. One day there was a bomb scare in 1986, I think, and the guys on the 13th floors and up and said, just check if those guys on the 5th floor are there. If they are there, it's a hoax. But yes, NADEL shaped me, because in 1985, the first state of emergency was declared. And something also that I've never mentioned in any of my application papers, I was still single. And I got the wonderful opportunity to won a Fulbright scholarship to do a master's in law at one of the most prestigious universities in the US, which is Stanford University, an Ivy League university outside San Francisco. And I got ready to go because I was single, I had no mortgage bond to worry about, and no family, and so on. And Dalla Umar stopped me one day in the passage, and he said to me, I understand you're going to the US for an LLM. I said, yes, Dalla. And he said to me, you can't go. He said, the first state of emergency is here. We need young lawyers. We need lawyers. We'll fight in the trenches. And I didn't go. And that is why I've got no LLM on my CV, in case you were wondering. But I can say it without any hesitation that I do not regret for 1 minute the fact that I stayed here. Because not only did I get to do many, many, many human rights cases at a young age as an advocate, but I learned so much about life and about politics from people like that. I was very privileged to be junior to heavyweight advocates in those years, like Dikgang Moseneke, like Pius Langa, like Marumo Murane, and so on. I can go on, Bernard Nwepe. I learned so much about life as a young man and about politics. And I learned that our struggle in South Africa is a struggle which demands all of us to give. And we made very little fees. I mean, we got paid from the International Aid and Defense Fund and the South African leg. And after 1994, when, after the first elections, in fact, after 1990 it started, the funds just dried up. IDEF in London said, well, the struggle is over. The people have been liberated, so now no more money. And I had to write off close to 200,000 rand. It crippled me. I had to give back one of the 2 cars I had. I had to sell my house. But we didn't complain because we understood that our people in the townships and in the rural areas were experiencing much, much worse than having to give up one of 2 cars, you know. And so, yes, it's shaped my life. I've been very privileged to work with great lawyers. I forgot to mention the late Tembile Squia. I was the first man with whom I went to the appellate division, as it was then called. And I was never somebody who occupied high position in any organization. I'm talking about NADEL and other organizations. I was one of the foot soldiers. I liked being in the background. I was young too, and so I was willing to learn, and I learned so much that those were wonderful years, despite all the suffering and the hardships. I'm sorry about the long, but it brings back good memories.
No, it is good. That was good. The other point that I would like to hear from you, of course, as you demonstrate even today, that you are not the person who is full of self-praises, who is selfish, will always look up to himself. You work for the people. I see that you have been involved in a number of trainings in the profession, in the judiciary. I was part of your trainings in the CJ, yes, for instance.
Yes.
How that shaped up yourself in terms of ensuring access to justice and understanding the lives of our people, which we must traverse through law and try to shape up.
Yes, as I said, I got involved through Justice Brandt, and I've been involved for the last 8 years of training. It's been very rewarding. Because the reality of South Africa is that we never got tax cases, shipping cases, and so on. And when we got to the bench, we had to work extra hard to understand what these cases are all about. And even now in the SCA, when I, for example, get a customs and excise case, I have to work extra hard to make sure I understand the subject. And the only way we can empower our people, and I'm talking about blacks, black practitioners generally, but also in particular females, is through training. And it's not an ideal situation because the best training you can get is in practice, when you work with a case. But if even with today's briefing patterns, the big corporates insist they want white silk, and they want a white junior, and they will put in a token third black, second junior, black junior, just for the show. And so the training is very important. And you know that we've done the best we could. When people get trained, I changed the system. Initially, we only had basic training where we give lectures. And I changed that system after 2 or 3 years because I thought, how would you evaluate, for example, Mr. Nochesi to see if he is ready to start acting? And we brought in the advanced training, which involves only practical work. You know, for example, I don't know if you did it, but we would give 10 unopposed motions to them at night. During the day we lecture, and I said, here's your homework for the night. Work on it tomorrow, we mark it. And we would then write a report to say, Mr. Nochesi is or is not ready to act, and we recommend him for acting, bearing in mind the other imperatives that the Constitution demands, such as demographics, gender, and so on. And so I think it's worked fairly well. There were obstacles, there were hurdles. We had to change a few things, how we select people. But I think all in all, I think we've done a fairly good job under the circumstances to train a great many people really to get involved in the law so that they could be ready to act. Because otherwise the pool will always stay this small because people do not get exposure to the kind of work that they should, the briefing patterns. Even the state attorneys still, in big matters, overwhelmingly brief white counsel because they believe that black counsel are not good enough. Which is very, very sad because it's like we were back when I started practicing in 1984. I mean, what has changed?
Thank you, Chief Justice. That is the mindset needed for the Constitutional Court, Judge Majiedt.
I almost said I wish you were the president.
Commissioner Schmidt.
Thank you, Chief Justice. Judge, I unfortunately need to refer you to that skirmish you referred to just now.
Yes.
And my question is, there appear to have been a bit of a uneasiness between yourself and Judge President Khomo and Judge Lekok, who appear to have lodged a complaint against Khomo in return for him lodging a complaint with the JSC. What worries me, and I'm just going to ask you because we don't have the record of the previous interviews, but there's a report that says that the JSC found the conduct of, it says here, of Judge Majiedt and Lekok using insulting and inappropriate language constituted unacceptable and unworthy conduct. Now, the first question is that correct? Was there such a statement by the JSC?
Yes, the Chief Justice then was Langa. What had happened was Judge Khomo laid a complaint against Lekok, Jay, and myself, and we laid a counter complaint against him. It wasn't a formal hearing at the JSC. We were asked to find each other and to settle. And after a long day, I remember Chief Justice Langa was still occupied that house in Houghton, which was allocated then for the Chief Justice. And after a long day, we compromised, we settled. He withdrew his complaint, we withdrew our complaint. We apologized to the JSC, and the JSC issued a statement that said, and this is the other important part, and I understand it, it's absolutely correct, I accept it, that although we are all judges, the judge president is primus inter partes. He is first among equals, and it must be correct. And so yes, that was the statement that was issued as conduct unbecoming. But I must emphasize that the JSC found that Khomo JP was wrong too, and that's why they asked him to withdraw his complaint. So that, Mr. Schmidt, is my answer. And again, I will repeat what I said in the last interview. If I had to do it over, I'll do it again. I'll stand up for my rights, but I'll do it differently. I'll do it in a manner that is becoming a judge of the High Court.
Thank you, Judge. But can I just ask, you referred to rights, and that's why I don't have the record. Which right are you referring to? Was it the right of being overlooked?
Well, it's the right to equality.
By being overlooked, sorry.
Yeah, I must sketch the scenario to you because, you know, the media latches on to the sensational part, and with great respect, they're not always familiar with all the facts. The facts were these. Khomo JP was the judge president, I was the next most senior judge. And as fate would have it, there were 6 permanent judges in that division, evenly balanced. 2 African, 2 so-called colored, one of whom was a woman, including myself, and 2 whites. The next most senior was Lekok J. The next most senior was Williams J, who is a so-called colored woman. The next most senior was Ulafir J, who is a white man. And the last was Laletsi J, who was an African man. And he was elevated above all of us to that position. Now, there is a long, very strong convention in our courts that the next most senior judge acts when the head of the court goes on long leave or goes away. And de facto, whenever Khomo JP had been away for a day or two, for example, attend the opening of Parliament and so on, he would ask me to stand in for him, and I did. And when I was away, perhaps on circuit, and he had to go away, then Lekok J stood in for him. But when it came to the push, when you had to be appointed, then suddenly you're not good enough. They take the most junior. And the way it happened was unfortunate because we asked up until the day he left on long leave, who's going to act as JP? No, he's still dealing with it. The minister and I are still dealing with it. The next day, I remember very well, we were driving to the coast on holiday. It was the first day of recess. My wife was driving. I got a text message on my phone. I said, can you look at this? And I read it to my wife. I was very upset and disappointed. It said that Lalesi J will act as JP. And my wife said to me, calm down and give it a day. I can see you're very upset. Call the JP tomorrow. And I did. I called him the next morning. And he said to me, I could hear he was driving. He said, man, I'm driving. I'm in a car with my son. It's an awkward discussion we're going to have. Would you mind me calling you back later? I said, by all means, I'm available the whole day. I'm on holiday. He never phoned me. And so I responded in the way he responded. I sent him a text message with intemperate language, which was, with the benefit of hindsight, completely improper. And so that was the facts on the table. And I've just felt that the only compelling conclusion that I could draw from those set of facts and circumstances was that A, I wasn't black enough, and B, that this is nepotism because Lalesi J and him both came from Mahikeng. And they had a long association as attorney and counsel, and so on. There's nothing wrong with it, but then you must do things properly. And that's all behind us. I was asked this question in 2010 when I came for the SCA interview. And the JSC was satisfied. I was asked this question in 27, and Homo JP sat there and he said to me, he said to the JSC, to this meeting, it's in the transcript here, he said, he just want to confirm that we met at the Kimberley Club as adult colleagues, professionals, and we sorted the matter out, and we've become good friends. He confirmed that, and he said, I've got the utmost respect for you, and as far as I'm concerned, that's Homo JP, is no longer an issue. So I regret that it's still an issue. I suppose it will always be a blot against my record. And I accept it but people must understand the context and must understand why I reacted like I did, which I say again was wrong in the circumstances, but I will never allow anybody to make me unequal because I'm not black enough. It was hard enough for us under apartheid because we weren't white enough. Now we're not black enough. And I will stand up for it every day that I have to. I make no excuses for it.
Oh, yes. Are you done, Commissioner Smith?
Only one question.
Sure.
Sorry, I don't have any knowledge of the matter except what you now informed me and from the record, I suppose. But was Judge Lecoq a black person, a judge?
A white person, white judge.
Because why I'm asking is, I'm just trying to understand why you are saying that it's a racial issue.
No, because the most junior judge is the only other African judge in the court.
Thank you.
I'm sorry, I thought the commissioners also have the transcript, which I got from the JSC, actually.
Yeah.
So, yeah, the transcript is here.
But just to address that, was it about the fact that he was African, or was it because there were tensions between the judge president and the other senior judges, or is it because of possibly the previous Mafikian relationship that he had, him practicing as an advocate and Lalesi practicing as an attorney? Was it more about whether one is so-called colored or African or white, or was it more about a prior relationship or some inexplicable preference?
Chief Justice, no, there were no problems in the division. We worked very well. We had the commendable practice, I think they still do, where we go out once a year, we go to a game farm in the Northern Cape, or we go to a place on the river with our families, and we bond for a weekend more towards the end of the year.
The problem only arose thereafter.
No, thereafter. I don't want, you know.
Okay.
I really don't.
No, you don't have to go into details. I've got a fair understanding. Remember, I was involved.
Yes, you were.
In attempts to mediate. Unfortunately, I didn't succeed.
Yes. No, Chief Justice, I just want to say I read, I think again in an article that I was being divisive. The facts speak for themselves, and I want to say to you, you know that I left there in 2010 to go to the SCA, and you know, and the JSC members who were members then know, that for the last 2 years you've been struggling to fill that DJP post in that province, and there are still rumblings of discontent from 2 female candidates. In fact, there were 3 candidates for that, some of the candidates, and I'm no longer there. So the rumblings of discontent has got nothing to do with me, so you be the judge as to who was divisive. I want to say no more than that.
Yes, yes. Commissioner Msomi?
No, thanks, CJ. Yes, good afternoon, Judge.
Good afternoon, Mr.
Judge, I wanted to ask you, you might have answered this question indirectly, but what do you regard as the most important human right that is in our Constitution?
You know, it's difficult to class them, but I think with our history and the preamble of the Constitution say so. Because our history, it must be the right to equality, and close second and tied to that is the right to dignity.
Thanks. As a follow-up question, if you were to be faced with a matter which involves hate speech, does the background of the utterer and the race of an utterer of an allegation of a hate speech a matter to consider when you adjudicate a matter of that nature?
Excuse me, it would of course depend on what the nature of the hate speech is, and we don't have full hate speech legislation in the country as yet. I should think that if it involves something that is, let me be upfront, the dreaded K word, it would matter whence it come from. Because I was taken aback. There's an ongoing court case, and I'm not going to say anything about the merits. You may know which case I'm talking about two giants, African men, giants of the South African business world. The one is the CEO of Investec Bank, and the other one, I'm not sure where he is, but he's a very, very prominent African businessman. The one is suing the other for defamation for calling him the K word. And I was taken aback when the defense was that, you know, we call each other the K word amongst ourselves all the time. It's like, and I'm sorry to use the word, it's like African Americans in the US calling each other a nigger. And so I was taken aback, and I think it must make a difference where that kind of language is involved, who the utterer is and what his or her race is. I mean, it must be so because nothing is in a vacuum in South Africa. There must be context to it, and the context is our history. Where does this history come from? May I just immediately add that there's a notion that only white people can be racist. Far from it. I've said to many, many people, I've spent a lot of time in the Western Cape when I went to university, and I practiced as an advocate there. And I have no bones about saying it. I said it in public forum at speeches already. Some of the most racist people you will find in South Africa, unfortunately, some of the so-called coloreds of the Western Cape. They are very fond of the K word. And I absolutely abhor that. I've got friends that I play golf with. When they try and use that word, I stop them and I said, you know, you can find yourself in 3 courts just because of that one word. You'll find yourself in the Equality Court, you'll find yourself in the Civil Court for defamation, and you'll find yourself in the Criminal Court for criminal injuria. And they are shocked when I tell them that. I said, that's the harsh reality. So yeah, racism isn't restricted to white people only. But I think, just to come back to your question, I think the race of the utterer must play a role when you have that kind of hate speech.
Thanks, Judge. I had that case in mind when I asked you the question that you made reference to.
Of the gentleman of Investec Bank and so on. It's a very sad case, actually.
Yes. Judge, just last one, and it's based on a very good report about you from the GCB. And they just make one comment, and they are inviting you to comment on it.
Yeah, I saw that, yes.
You saw that?
Yes.
Do you want me to read it out, or do you know what I'm talking about?
Well, let me check. Is it the question of what I said about gender?
Yes, yeah, it is 2.11.
You can see I'm well prepared, eh?
Yeah, I see. Yeah. No, without a doubt, Judge.
It should stand me in good stead at the Constitutional Court.
So the book that you'll find this in,
yes.
It's a book titled Feedback from Law Bodies, Book 2 of 2.
Yeah, no, I've seen it, yeah.
Yeah.
I have my records here.
Yeah.
If I can get to the place, but I can remember it because I read it last night again.
Yeah. Basically what they are saying is that you, at the last interview, you said in the words to the effect that you couldn't really wait for female representation to increase before applying for the position.
Yeah.
And obviously the interpretation that then gets given to that is in clause 14.2 of their report, where they say the candidate's comments regarding female representation in the legal field raises doubts as to the candidate's ability to advance the values of the Constitution. So just that comment, they say, raises doubt about your ability to advance the values of the Constitution. And it is that comment that you are invited to comment on.
Yeah.
Thank you. That's enough.
I can find it in the transcript, but the context there is wrong. What I'd explained there is I was asked about gender, and I said, if you have a man and a woman of equal merit, then of course the woman must be appointed, all things being equal otherwise. And I also said that if you just consider my position, and I made the example, I acted in the Constitutional Court in 2014. That was the year when the late Tembile Skweyiya J retired. At his retirement, at his farewell sitting, the Chief Justice presided, and he said bluntly he wants a woman for that post. And so I waited. I stood back, and I think 5 women made themselves available, and our former colleague of the SCA, Mhlanhla J.A., was appointed to the Constitutional Court. And remember, vacancies in the Constitutional Court do not come up all that frequently. And so when the next round came up, I said to myself, well, I've waited this round, I'm going to make myself available. And so I said in the interview, am I supposed to wait until, let's say, there are 5 or 6 women in that court who may never get there, unfortunately. And so that's the context of it. So I'm very pro-gender. I mean, you can see in my training and so on, the people who get selected and so on. And I support women. I've never had a sister, and I've got 3 good sisters at the SCA. One is now at the Constitutional Court, and they are all African Xhosa women. So I've got no problem with gender. I subscribe to it fully.
Thank you so much, Judge. Thanks, CJ.
Thank you, Commissioner Msomi. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge.
Good afternoon, Mr. Nyambi.
The challenges of the SCA. Before I can conclude and have impression that the survival of the fittest, because I like how you're able to deal with your own issue. Maybe if you can share how you're able to assist somebody who was acting something that was significant in terms of your contribution showing leadership, so that you can deal with the perception that is being created that it's more of a survival of the fittest.
Yes. No, thank you, Mr. Nyambi. I've said that I think women acting judges and junior judges are vulnerable because they are regarded as soft targets. And I'll be honest with you, I don't have the guts to go to a senior judge to say you were wrong here. I leave that to the head of court. I report that to the head of court and say, I think you must intervene, and I've done that in the past. What I have done is, the colleague came to me, I'm just going to use this last example. She said to me, there's this hullabaloo about the judgment I wrote, and the man was extremely rude to me. It was so bad that that colleague went to her chambers and he shouted at her so that colleagues in the other chambers heard. And I said, well, let's have a look at the judgment that you wrote and the judgment that a colleague changed and see where the problem is. And when we analyzed it, we went through it, and I could see that there was really no changes of substance. He'd move a paragraph there, he changed some words here, and then there were 1 or 2 paragraphs of substance. It was a matter concerning the Companies Act and the company resolutions. It was not an easy matter. And the point that the senior colleague was upset about was he was saying this other colleague who helped you, who was a white acting judge, his name should be on the judgment, not yours. And I said to him, well, for the life of me, I can't understand why he says that, because 70 to 80% of this work is your work. I mean, I can't come to you and say, Mr. Nyambi, I think instead of saying, there were 6 of them, you rather say there's half a dozen of them, and then you highlight it in the judgment and say, hey, this is my judgment. I mean, really, it's literally 6 of the one and half a dozen of the other. And so I said to her, I think how you should handle this, you should stick to your guns and say, this is your judgment. Speak to the other colleague who made these changes and say, do you want your name on the judgment? That colleague said no. Also an acting judge said, no, I don't want my name on the judgment. And so we don't understand why the presider is insisting on putting his name with yours. Unfortunately, one doesn't want to always draw the most adverse inferences. But the inference that you draw in an instance like that is the man is trying to belittle this woman, to show her that she's worthless, to show her that her name doesn't belong on this judgment, which eloquently talks about the Companies Act and company resolutions on their effect and so on. And so he wants to belittle us so that somebody else is. That's unfortunately the influence, unless he persuades you otherwise. And so I said to you, stick to your guns, talk to the other colleague, but you do not take your name off this judgment. In the end, it all ended fairly well in that the senior colleague, I think, accepted things as they were for some other inexplicable reason. But the damage was done. That acting judge has left our court with a very bad taste in her mouth, understandably so. She's had a very bad experience that she left that court with, and it reflects on all of us, not just that colleague that was responsible, it reflects on all of us.
My last question. When you were appointed a judge almost 20 years ago, you were relatively young.
Yes.
Being here today, approaching 60. If you can look back, anything that you, with hindsight, have some regrets as a judge?
Well, the one thing is the Khomo JP incident. And the other regret that I have is that when I had, and I know the people in the Northern Cape are going to hate me for that, in the Northern Cape bench. It's a very quiet bench. There wasn't much happening there. So you had ample time. The 10 years that I spent there, I should have furthered my studies did in LLM and perhaps an LLD because I had time on my hands. That's the one regret I have, and I know they're going to be very upset with me. CJ, you know, you were in the Northwest. They say, you were the SA, now you want to make our court as if...
I already had my master's.
You see. But yes, those are the two regrets. For the rest, if I had my life over, I'd become a lawyer again and I'd follow the exact career path. Because I said in my last interview, I come from the rural areas. Very small town, Kennard. Most of you around this table don't know where that is. But I have a lot of affinity and affection for the people in the rural areas because I think they are grossly neglected. Everybody's going to the cities and that's where things are happening. So yes, I wouldn't change anything, and I have those two regrets in my life, professionally, otherwise nothing.
No, I'm proud of you. I'm also from a rural village in Mpumalanga.
Yes.
Thank you, Judge. Thank you, CJ.
Thank you, Honorable Nyambi. Commissioner Fori.
Thank you. Good afternoon, Judge Majiedt.
Afternoon, Mr. Fori.
Commissioner Msomi has already dealt with the GCB issues and the Khomo issue, so I'm not going to go there. Just one thing. If I understand the documentation correctly, you had one stint in the Concord, and that was February to May of 2014, which is...
2 terms.
Well, 2 terms, but that's the period.
That's the period.
February to May 2014.
Yes.
And that is almost 5 years ago.
Yes.
And I'm just curious to know, is there any particular reason why you have not acted there since? I assume you're going to tell me that you were not invited to act there again.
You only go when you're invited.
Is there a particular reason that you might be aware of why you were not again invited?
I have no idea. You should really ask the Chief Justice.
The fact that it's been almost 5 years since you've acted in the Concord, do you see that as any disadvantage to your application to permanently sit there?
No, I don't think so, Commissioner, because I've kept abreast, I have to, of the developments in that court, because, of course, that court's precedents bind us, so I've been following that court very closely, and I've made a lot of friends there, and the reason why I'm here again, so shortly after 2017, is because some of the colleagues in that court have asked me to make myself available because they think I can contribute. So no, I don't think it can work to my disadvantage. I should hope not.
Thank you, Judge.
Yeah, the Chief Justice has run away, so he understood your question, what your answer was going to be. Commissioner Didiza is next.
Thank you very much, Judge Kachalia. Good afternoon, Justice Majiedt.
Good afternoon, Commissioner Didiza.
How are you?
Very good, ma'am. I hope you are too.
I am.
I know you must be tired by now.
Not yet.
Good.
I was looking at the judgment you penned out in respect of the land claim, which was a matter between Mokala
Oh, yes. Yeah.
as versus Minister of Rural Development and Land Reform.
Yes.
And I understand how you reasoned on that matter and actually admonished the state in the manner in which it dealt with the payment
Yes.
to the landowner for that land. I just wanted to hear your view, even though it's not a directly related manner, that if you look at Section 25 of the Constitution, where it deals with the payment of compensation, it actually talks about time and manner of payment,
Yes.
which must be just and equitable as it stands. Whether or not, in your understanding, that time and manner actually means when you expropriate, you would need to make a payment up front, or you can expropriate and at a later date make that transfer to the affected individual.
Yes, Commissioner, I think what that means is that, of course, you can get two types of expropriation, either by the state or the parties have reached some sort of agreement and then compensation must be paid by the agreement, which must be approved by the court. That's what the section says. I take it to mean that unless the parties have agreed as to the manner and the time payment is to be made, a court must determine that time and manner of payment, and that means that how long after expropriation must payment be made. Sometimes what normally happens, absent an agreement between the parties and absent a specific court order, we fall back on the position that it should be within a reasonable time. What is within a reasonable time will depend on many circumstances, but that's how I understand that particular section to read.
Thank you. The second and the last question relates on the matter of Leicester versus Ndlambe municipality.
Yes.
You know, I've read the judgment, and partly I was wondering on your reflection on Section 26 of the Constitution. In a manner where a building structure is not done according to plan, who then bears responsibility for alternative accommodation in this instance?
Well,
Is the expectation that it must be the municipality, or who?
Well, it should be the landowner, because remember, the landowner is in breach of the law. And on the facts of that particular case, Professor Lester is a tax professor at Rose University. We said that he has the means to find alternative accommodation, unlike somebody who's indigent, where you may have to find whether the state should bear that responsibility. I should think generally, you look at the means of that particular landowner, and that landowner, because he or she or it is in breach of the law, must bear that responsibility. We can't still shove that costs onto the fiscus, to the municipality, which, as we all know, is already in dire straits as far as finances are concerned generally in this country. But on the facts of that case, we found that he's by the means to bear those costs himself. I must just say, while you're dealing with that case, there's been a controversy about that case, and I think DGRU or the GCB mentions that in a subsequent judgment, colleagues found that that case may be wrongly decided. The name of the case is BSB International versus Redem. It's reported in the law reports. And in that case, I wrote a separate concurring judgment, and I pointed out that the colleagues who decided this point was doing so obiter dictum. In other words, it wasn't necessary to decide the point. And that again was an instance where I felt that the colleagues tried to belittle not only me, but also those who sat in that case. And Kachalia J.A. happened to be one of those who sat with me in Leicester and who agreed. It was a unanimous judgment. The presider was Mtiane DP. Because I pointed out in my separate judgment that that case, the Leicester case, which I decided, and which not we decided, and I wrote, went to the Constitutional Court for leave to appeal, and they refused leave, which to me means implicitly that they agree with us, that there's no reasonable prospects of success. And yet, The colleagues found it necessary to make an obiter dictum remark to say, we think this judgment was wrongly decided. And what is more is that it was never an issue in the case. Counsel was taken aback when the point was raised. They were asked to submit supplementary heads. The judge in the High Court never had to decide the case. It had nothing to do with the case. And I just felt aggrieved that this is one of the instances, again, where people want to show you up and say, you know nothing. You and the other four who sat there, and mind you, the Constitutional Court too, don't know what you're doing because we think this is wrongly decided. It's very unfortunate. I'm sorry, I had to get that in because...
Thank you, CJ.
Thank you very much, Honorable Didiza. Justice Kachalia.
Yes. Thank you. Could I? You've been at the SCA for what? For 9 years.
9 years.
In general, have you found that you have grown, that your experience, your experience as a judge, you've improved your capacity for legal reasoning and judgment writing? In general, has it been a positive or a negative experience for you?
No, there's absolutely no doubt that I've grown tremendously. As I said, I came from a small division. I became one of the senior judges in the small division, so I wrote many judgments on more advanced legal matters other than just the normal run-of-the-mill stuff. When I got to the SCA, I went there with a mentality that I'm going to learn and learn and learn. And I'm one of those who I'm never shy to go and ask. And that's the one thing that I must just interrupt myself to say, Chief Justice, that bothers me in our court. Many of the, I think it may well be because of the reports they've received, but many of the acting judges and even some of the junior judges, I don't know what's your experience, Judge Kachalia, but very few of them come into your chambers and say, man, don't you want to help me with this and see whether we think. I've learned that there's no replacement for experience in our job. It's so with most jobs, but especially with the law and on the bench. And I've never been hesitant. You know yourself, Judge Kachalia, that I've often gone into senior colleagues' chambers and say, just debate this with me and see where I'm wrong. And I've been persuaded by colleagues that I'm wrong, and or they've helped me on the right path. And so, yes, I've grown tremendously. When I read some of the stuff I wrote in 2010 and 2011, I'm horrified. I've certainly grown as far as judgment writing is concerned. I think, and again, I'm trying to be humble, that I write well now compared to when I got there. Definite improvement.
Now, among the areas I've been exploring with other potential candidates is now that the Constitutional Court has been given some level of, it's not complete general jurisdiction, but it's general jurisdiction in relation to matters of importance, of particular important points of law that are of public importance. I forget the exact language.
Yeah, I think general public importance. Yeah.
Yes. Do you think that your experience in the SCA in relation to areas such as delict, contract, and tax, is it a relevant factor for appointment to the Constitutional Court, or is it a neutral factor for appointment to the Constitutional Court?
I believe it's very relevant because, as I say, that jurisdiction has expanded, and there will be many, many of these cases coming through, those that can be classified as of general public importance, which are cases that are not purely constitutional in nature, if I may put it like that. And so I do believe that it's important that when the JSC makes a recommendation, that is something that should be taken into account, and with great respect, when the President exercises his prerogative, that's a factor which should certainly weigh. I must just, yes, I would just leave it there. I think it's of great importance. That court is going to get more and more of these cases coming through.
And finally, I know you to be a very friendly person, sense of humor, But I have also realized that there is a line that ought not to be crossed. What is it that gets to you?
Sure.
Because generally you're humorous. Most of the time. It's very, very rare. It's very difficult to annoy you.
Yes.
So what is it that, that really strikes that chord?
Chief Justice, I have so many shortcomings. I can't believe you say that. One of the things that I think I can be intemperate, although it may not look like it, I lose my temper sometimes. But speaking about my work, I think the one thing that I detest is that people do not accept me for the worth that I am as who I am. I am somebody who comes from a fairly privileged background, having been brought up in a home where my father was a schoolmaster and later on the headmaster of a school. My mother was a teacher, and I much better than many, many, many black South Africans. But I also come from a background where I was deprived. I was deprived of opportunities. When I look at some of the cases that I have to deal with, and for example, tax and customs and excise, then I wonder, why were we not good enough back then to get these cases as advocates? And you realize it's just law. It's a different kind of law, but it's law. A friend of mine who practices as a silk in Cape Town tells me that he got a shipping case recently, and for the first time in his life. And he wondered, but what is so special about this? Why were we as black people not good enough to get shipping cases? There's a black advocate, an African advocate, Advocate Mpofu may know, I think it's a him, or maybe a her, who's got an LLM in shipping law. That person has never received one brief in shipping law. It all goes to White Council. Why? And so just to answer your question, I want people to accept me for what I am and for what I'm worth. That is why I got so angry when I was overlooked, because I thought that this is discrimination all over again, just from somebody who's not white. And so I have a lot of shortcomings. My temper can sometimes be short. But generally, I'm a jovial person, Chief Justice. I make friends. In that court, I can tell you, Judge Kachalia can correct me if I'm wrong, I'm friends with everybody. Yes. And in as much as there may be groups, and I put them in inverted commas because it's not strictly delineated as groups, I'm friendly with everybody, and they know that I have a very simple philosophy. I sit in my chambers, I do my work, I go to court, I go to the tea room, that's it.
And then you make a lot of jokes.
I do.
Thank you very much, Judge Majiedt.
Chief Justice, I must just, in conclusion, mention to you, when you were absent, Mr. Fourie asked me why didn't I act in the Constitutional Court after 2014, and would that count against me? And I said, I don't know, you must ask the Chief Justice. I just want to leave you.
Thank you very much, Justice Majiedt.
Thank you.
Thank you.